has given a bail condition, a circuit court or a high court can reduce it. And that they could have done easily. I don't see where he's taking this from. What Raymond Archer said is, assuming the issue you are contending with is $5 million, as you said, and you give somebody the bail sum of 5 million Ghana cedis or 10 million Ghana cedis, and the person decides that, yeah, I'm really guilty, let me abscond, and my surety, they can pay the 10 million and I keep whatever million I have. That is some of the things that go into grant of bail. Senior, as you said, we have had this discussion before. If a police officer, IOCO, or whichever body has given bail, and you feel that it's excessive or onerous as it is, you apply to the court, the high court, as they've done in Provençal's case, to get it reduced. Even when the courts themselves give bail and you feel that it's excessive, you sometimes apply to the court to get it reduced. The idea that it's excessive, we cannot really say, except they tell you that we are going to use the bail as punishment to hold you. They don't. And again, let's educate our people. I am getting the impression you mean that when they ask you to bail condition of 50 million, it is like you are to pay the 50 million. No, you are not to pay the 50 million. So asking
that is the philosophy behind it.
No, that is not. You are not supposed to pay 50 million. Is the situation where the sureties will guarantee that they will bring you to court. The whole purpose of bail is to bring somebody to court, to appear before court.
No, but the sureties.
Yes, the sureties.
They are supposed to show property worth.
Yes.
Worth the amount.
Sina, I don't know whether you've heard that when a certain judge, she's now in the Court of Appeal, she says unless she specifies the type of surety, she's not asking even for landed property. So you could go on to challenge or ask whether they really needed landed property in terms of the sureties. It could be to guarantee just by posting affidavit of surety to show that you are ready to, when the person absconds or is not ready to appear before court.
No, we know that.
Yes.
Once the decision is that the surety is to be justified,
yes,
then you really will need the property worth that value.
Yes. Senior,
and this is the circumstance they are fighting.
Senior, you see,
and he's telling you that to the extent that the court is looking at it with a different view, you give 60 million and the court casts it to 30 million, it shows that you are being excessive.
No. Senior, the courts themselves can give 60 and you go back to the same judge. Look at the Asibe case. They went back to the judge and the judge reduced it. It doesn't mean that the judge himself realized that what they have given is excessive. If the judge realizes that they are excessive, they reduce it. It doesn't mean it is somebody who has influenced the judge or using it as punishment. It is that you look at the circumstances. You go back. We do it always. Bail conditions are given even by the court. You go back to say, even that day, you tell my lord, my lady, that looking at the circumstances, my lady, this particular type of bail is as if you have refused the bail. Our application for bail. So, my lady, kindly reduce it or look into it and give us something that we can be able to.
He's saying that some of these people, almost all of these people, please hold on, almost all of these people, they are public figures. All right? Why don't you exercise the discretion to grant them self-recognizance, where they only come and then they show you their ID card, and that's enough. Then you let them go. Or perhaps even just, detain their passports.
Yes, something. You use the word discretionary. The person who exercises that discretion would have had the privilege of having certain information that yourself, myself, don't have. That is in the wisdom of that person and using that discretion. This is what I will give to make sure that you appear before us or you appear before a court of competent jurisdiction the next time you are asked to come. We have had a situation we just discussed this morning where people have absconded. So there is history. At least certain things inordinately or inarticulately would have been at the mind of somebody exercising discretion. It is not, the idea that is excessive is neither here nor there. If it is excessive, we have had this discussion before. Go to court, ask the court that it is excessive. The court will reduce it. You don't lose anything. The only other thing you lose may be your application and your advocacy. So for me, I don't see this to be a big issue. That the one that worries me is to ask the AG why the courts are even giving those type of terms. The AG does not control the courts. The courts have their independent minds and their independent way of...
Is the AG who applies...
No.
The Supreme Court has said...
Is the AG...
The Supreme Court has said that bail is not ministerial.
Yes.
It is judicial.
Yes.
So if police inquiry bail, as IOCO, OSP, and co are doing, they give you bail and you're not able to meet the terms, within 48 hours, are they not supposed to take you to a court for a court to determine your bail because you are not free? The law says you have to be released
within 48 hours.
Either unconditionally or on a condition.
If you go to section 15 of Act 30, it says that the bond may be enforced as if it were a bond executed by order of court. So if the police or IOCO gives you bail with those conditions and you are not able to meet it, it is as if the court has given you those conditions and the same way they will enforce it. So it is not a matter of they've given you bail, you've not met it, so within 48 hours or after 48 hours, take you to court. It's in section 3 here as well.
Section 3 says what? Read
says that a person referred to in, that is custody of person restricted, may at any time before or after the expiration of the period of 30 days be required to enter bond with or without sureties for a reasonable amount to appear before the court or at the police station or place and at the time as stated in the bond. The bond may be enforced as if it were a bond executed by order of a court and condition for the appearance of that person before a court. It is section 15 that the police, the IOCO, etc., have that authority to grant bail or not. And the section 15.3 says that that bail that they will give you, it is as if the court has granted you bail. You cannot say, senior, if you appear before court and the court grants you bail and you are not able to meet the bail conditions, because of that, they should release you or they should take you back to court within 48 hours again. If that is the situation, that cannot be. Okay. So the idea that you have been granted bail in IOCO or police and you have not been able to meet it, senior, it just means that we have released you. Meet these conditions and go home. You've not been able to meet them. If you feel that our conditions at police station, IOCO, NIB are too much, go to the court, as he said in 96.2, to say that the conditions are excessive. Please look into it as it's done in Professor.
Okay. Dr. Kennedy, what are your thoughts on this about the bail? And it's notoriously known when people are public figures, when people are MPs,